So one of the things we see in a lot of disability insurance denials is that the claimant's medical condition doesn't change at all after they've either been on claim for a couple months or years, and then all of a sudden they get this denial letter in the mail. So my question to you is, if a claimant's medical condition doesn't change at all, how can the disability insurance company deny their benefits?
That's a good question, Greg, because in most cases that we see, that's exactly the case. The condition hasn't changed. In some cases, it might have even gotten worse, and the disability insurance companies denied the claim. And it's all a matter of interpretation and perspective. So the disability insurance company is gathering this information, the records, they're having this, all the information or records reviewed by personnel inside their company or sometimes outside of their company, a third-party vendor or something. And those people, those individuals that are reviewing these documents and these records are looking for reasons specifically to terminate or deny a disability claim. So even though there may not have been any change, the interpretation that that peer review physician or that financial analyst or that vocational assessors interpreting and registering is going to produce a denial or a reason not to support the restrictions and limitations that may have been in place for years, months. So.
And I understand how frustrating it is. You have a claimant who has a neck problem or a back problem, positive findings on an MRI or a CT scan, and they've been getting paid for a year and a half. There's no change in their disability definition. All of a sudden they get a letter that says, "We think you can work now." Mm-hmm. And it's like, how did that happen? I didn't all of a sudden get better. My neck didn't get better. It's proven there on the scan. It's not going to get better.
And the insurance companies internally, they go by these guides or these protocols that say, okay, well, this person has this condition. It should take them this long to recover. Or they had this surgery or this treatment, and it should take them this long to recover and be able to get back to full-time work. So that's part of it too, is that they're setting targets on you, whether it be 6 months, whether it be a year, that once you finish your treatment, you should be ready to go back to work. And if they don't see or perceive any objective findings or evidence inside the records and inside the file that they have, they're going to deny the claim.
And there's a couple times I see this, again, where the person's on claim and then they get denied with no change. Is number one, a change in the person who's handling their claim at the company, because that person wants to be a hero. Number two, they'll randomly send a letter out to the claimant's treating doctor saying, can your claimant do A, B, C, D, and E? Or does your claimant have any restrictions and limitations, without even explaining what the basis is for those questions, meaning not even telling them, like, for example, somebody might be a financial planner or commodities broker and just say, do they have any restrictions and limitations, but not applying it to what they do.
Right.
So I see it in that scenario a lot. And then obviously they'll send them for an independent medical exam. There's so many different things they can do, but the best way to combat that is to always make sure you're documenting all of your complaints and continuing to treat with your doctor.
Right.
And I think that's how you avoid that. So if you have questions about your claim, feel free to call any of our lawyers. We always offer a free consultation, and we welcome the opportunity to speak with you.